Hello everyone, and thanks very much for tuning in for this episode of Gough Square Live. I'm Robin Kingham, and today I'm joined by Ruth Bala. Today we're going to be talking about the relationship between the Financial Conduct Authority and the Financial Ombudsman Service. In particular, we're going to be discussing a recent report made by the Complaints Commissioner, which considered an allegation that the FCA was inappropriately influencing the FOS. We're then going to use that as a springboard for a more general discussion about how the FCA and FOS interact and what we should take away from this. So, the structure for our talk today will be as follows. First, I'm going to give a brief overview of what this report was about. Then I'll hand over to Ruth, who's going to take a look at the legal framework that underpins the relationship between the FCA and the FOS, and also consider whether the FCA should be advising the FOS at all in the way that it has been. I'll then pick up on that to elaborate a little on what the issues will be if the FCA and the FOS continue to interact in the way that they are. Finally, we'll then talk a bit about what, in our opinions at least, needs to change. I know that's a lot to get through, but we're confident that we can cover this in 20 minutes or less, leaving 5 minutes or so for questions at the end. Now, as always, this is a live broadcast, so you can participate. If you have any questions at all, please do ask us during the show. You can post them on the live chat, or you can send them to us by email to goughsquarevl@gmail.com. That's Gough Square, Victor Lima, all one word, lowercase, @gmail.com. Right, so onto the report itself. This was a report published just last week by the Financial Regulators Complaints Commissioner. This is perhaps a not very well known, but nonetheless independent adjudicator to whom people can complain if they're unhappy about how they've been treated by the FCA, the PRA, or the Bank of England. Now, the Commissioner doesn't in fact have the jurisdiction to consider complaints made about FOS, which made this report perhaps even more unusual than it already was. But in any event, as the Commissioner sets out in his report, it was impossible for him to consider the complaint without hearing about FOS, so an exception was made. I'll summarise the facts very briefly. The complaint arose out of an investigation undertaken by the FCA into the investment business of a unnamed firm. Both the identity of the firm and the nature of the investigation haven't been made public, but what we do know is that the investigation into that firm was later dropped, although an investigation was then started into 2 individuals at that firm. Whilst that was going on, some of the firm's investors made complaints to the FOS that we can only assume related to the same facts that formed the basis of the FCA investigation. In June 2015, the FOS issued a provisional decision rejecting a complaint against the firm. At some point subsequent to that, there was communication and at least one meeting between the FCA and the FOS in which the FCA said that it disagreed with the FOS's provisional decision rejecting the complaint. In particular, the FCA apparently took issue with the FOS's interpretation of rules contained in the FCA Handbook. Now, we don't know what those rules were or what the issue of interpretation was, but we do know that the FCA seems to have advised the FOS on what the correct interpretation of it was. Now, crucially, that advice was not provided to the firm or made publicly available. As a result, the firm made a complaint to the Commissioner on several grounds. Among other things, it said that it was wrong for the FCA to comment on any case that was in the process of being decided by the FOS, and also that if the FCA was going to give its own interpretation of the rules, then that should happen openly and in a fully published manner so that all the parties could see what was going on. In reply, the FCA said that there was nothing wrong with it commenting on cases before the FOS, and specifically that this was permitted by both FSMA and by the Memorandum of Understanding that serves as the framework agreement for the 2 regulators. The FCA also said that whilst it would be inappropriate to suggest a course of action in relation to an individual complaint, it was fine for it to advise the FOS on the interpretation of rules and guidance. So, what did the Commissioner say? Well, I've set out some key extracts from his report on slide 1. Could I have slide 1, please? Right at the outset of his analysis, the Commissioner noted that it was, quote, common ground that the FCA must not seek to influence a decision by the FOS on a particular case, end quote. However, beyond that, views differed between the parties. In the Commissioner's view, as a matter of general principle, the FCA had a legitimate interest in decisions made by the FOS, including forthcoming decisions. Further, there were situations in which the FCA could provide advice and guidance to the FOS during the decision-making process. However, care must be taken to avoid improper influence by the FCA, or even just the perception of it. Turning to the specifics of the complaint, the Commissioner came to a somewhat, perhaps equivocal conclusion. He said that he couldn't uphold the complaint of improper influence by the FCA because there was simply no clear evidence to demonstrate it. However, that said, he also found the situation very unsatisfactory, and in particular disapproved of the absence of any proper records to explain the FCA's purpose in sharing information with the FOS. Perhaps even more significantly, the Commissioner also explicitly refused to endorse the FCA's approach to the whole situation. The mere fact, he said, that there was some general backing for information to be shared between the two organisations didn't in itself justify the sharing of information in this case. Finally, and before I hand over to Ruth, I think it's probably worth noting what is, in my view at least, conspicuously absent from the decision, and that is any reference to natural justice. Now, of course, it's trite law that natural justice requires that any person at risk of being penalised by a decision of a judicial or quasi-judicial tribunal should have a fair opportunity to respond to the case being made against it. And from the report, it seems that that wasn't the case. Even if the FCA is providing what in its view is a neutral interpretation of its rules, it seems only right, at least in my opinion, and perhaps Ruth's as well, that the subject of the complaint should have access to that advice and the right to respond. The fact that in this case the FCA was actually intervening in a non-neutral manner, by which I mean that it was disagreeing with a provisional decision in favour of the firm, really should only have increased the importance of allowing the firm to respond. That's my view, at least. Right, well, that's enough of me for the moment. Ruth, I'll hand over to you now to discuss whether there should be any interaction at all between the FCA and the FOS during the decision-making process.
Thank you, Robin. As Robin's just said, I'm going to address the question of whether the FCA should have any input at all during FOS's decision-making process. It seems that the input the FCA had here was to convey its interpretation of its own rules or guidance. It's unclear from the Complaints Commissioner's decision whether it was rules or guidance which the FCA was seeking to interpret. Is there any scope for that sort of input? Could I have slide 2, please? This is DISP 3.6.4r, which sets out the test for FOS to apply. You can see there, Rule 1b, FOS must take into account FCA rules and guidance. Sub-Rule 2, FOS may take into account what it considers to have been good industry practice at the relevant time. That's its own view, not anybody else's view. Therefore, how should we classify the FCA's input on the interpretation of its rules or guidance? In my view, it is in effect further private guidance. The FCA is giving guidance to FOS beyond the published guidance. It's giving private guidance which embellishes or expands upon its published guidance. The FCA does have power to give guidance, and that derives, if I could see slide 4 please, from the Financial Services and Markets Act 2000, section 139A. Guidance is there contemplated to consist of information or advice, which would be apt to encompass the FCA's input here. Does it encompass the FCA's input here? Was this guidance pursuant to section 139A? I note that the FCA's power to give guidance in 139A is not confined to its ability to give general guidance. General guidance is a term used in section 139B, which isn't on the slide, but effectively that's the sort of guidance addressed at 139A, subsections 3 and 5, which is back on slide 4. Could we see that for a moment again, please? So general guidance, if you look at subsections 3 and 5, is guidance to be given either to the general public or to authorised persons generally, or a class of authorised persons. However, there's also the scope for the FCA to give guidance which is private guidance or guidance to individuals. If you look at the principal guidance power in subsection 1, that also embraces the ability to give particular guidance. If we could look at slide 3 now, please. Further detail on the ability to give particular guidance is set out in SUP, which is the supervision module of the FCA Handbook. So the FCA may also give guidance to persons, and this is addressed in SUP. The glossary definition of persons includes individuals or body corporates, and FOS is a body corporate. So potentially within the scope of SUP there. Such guidance is termed individual guidance. Look, for instance, at the guidance provision in 9.1.2 of SUP, which is back on, I don't know whether that slide's still visible, but that was back on that slide. Individual guidance may relate to the particular circumstances as set out in SUP 9.1.3G. Going back to slide 4, which contains FSMA section 139A, you can see that the FCA's power to give guidance is expressed in very broad terms. There's a governing limitation, it considers appropriate, which is hardly a limitation at all, and the relevant subjects of the guidance are the operation of the FCA rules or any other matters the FCA considers desirable. However, in my view, individual guidance is not contemplated to extend to guidance given by the FCA to FOS, even though FOS may fall within the glossary definition of a person. Let's look at some specific statutory provisions on the relationship between FCA and FOS. Turning to slide 5, please. FSMA section 232A provides, in that slide, for an information flow from FOS to the FCA. However, it can be seen from that section that the purpose of the flow is to advance the FCA's operational objectives. That's put at a very high level. There's no specific statutory provision in respect of information flow in the reverse direction, i.e. from the FCA to FOS. Nonetheless, that's not to say that such a flow cannot occur. If we look back at slide 5 to FSMA Schedule 17, paragraph 3A, it's contemplated there that the FCA and FOS must take steps to cooperate. Cooperation would include the provision of guidance, but that cooperation is in the exercise of their functions. Again, a high-level concept mirroring the wording of section 232A above. That is to say, the entity's interaction is confined to a general level, a high level of functions. If we look at slide 6, which is the Memorandum of Understanding between the two entities, we can see that there is provision in paragraph 19 of the Memorandum for an information flow in the reverse direction, i.e. from the FCA to FOS. Although that's not in the statute, it's permitted to be included in the Memorandum of Understanding. But that information flow is specifically connected to aiding FOS's functions. So again, that reflects Schedule 17, paragraph 3A, the reference to functions. The duty to prepare the Memorandum of Understanding derives from paragraph 3A, subparagraph 2 of Schedule 17. So, providing guidance in the context of a live complaint before FOS does not relate to FOS's functions, but rather to its decision-making process in a particular case. The purpose of the FCA's input could only be, surely, to influence the outcome of that decision-making process, i.e. to influence the decision. Now, in the context of a Complaints Commissioner's investigation, it seems that the statements from the FCA are perhaps quite carefully worded. They do not technically deny influence by the FCA in respect of a cohort of cases before FOS. So, if one looks at the FCA decision, which was made prior to the Complaints Commissioner investigation, the FCA concluded that there was no improper influence of FOS, which is quite distinct from a conclusion that there was no influence of FOS. If we look at slide 1, which sets out some extracts from the Complaints Commissioner's report, at paragraph 16, it's recorded that it's common ground that the FCA mustn't seek to influence a FOS decision on a particular case. But that statement from the FCA leaves open whether the FCA has been seeking to influence FOS in respect of cohorts of cases, which wouldn't fall within that statement there. So, for instance, has the FCA been seeking to influence FOS's decision-making in the cohort on these facts? Or what about in a cohort of cases before FOS, such as solar panel mis-selling Section 75 cases, or PPI complaints that would be time-barred if issued in court? We just don't know because of the lack of transparency. If influence by the FCA has been occurring, that gives rise to two concerns. Firstly, in respect of transparency, as Robin alluded to, but it also taints the FOS process. If we look at slide 5, which sets out the foundation provision for the establishment of FOS, Section 225 of FSMA, FOS is the scheme operator referred to there. And FOS is described as an independent person. That is its core attribute, i.e. it's independent from both the complainant and the regulator, the FCA. For this reason, any involvement by the FCA in the FOS's decision-making process should be both restricted and transparent. If I go back to you, Robin.
Yes, well, just picking up on some of the points that you made there, actually, Ruth, in particular that point about transparency that you alluded to, I think it's probably worth considering what the industry might suspect, at least, is going on in the absence of a properly transparent process. Anecdotally, I think it's fair to say that there's been some concern that what the FCA is actually seeking to do here is to retrospectively enforce through the FOS. By that, what I mean is that where, for example, the FCA comes to the conclusion that perhaps at some point in the past its rules weren't as clear as they should have been, or they didn't properly regulate certain activities the way that the FCA might have wanted, that the FCA has then been intervening in the FOS process to make sure that the right outcome, whatever that might be, for consumers is reached. Whilst that approach might be understandable from the FCA's perspective, it does, of course, pose serious difficulties for firms. Right, so where do we go from here? The FCA has issued a short response to the report stating that it notes the invitation to discuss with the FOS whether there should be clear guidance about the circumstances in which information should be shared between the two. I think, in our view at least, this is really the bare minimum. The Memorandum of Understanding is clearly inadequate insofar as it regulates this information sharing, as this case has demonstrated. I think in order to retain confidence in the regulators, firms will want to see a detailed framework agreement covering exactly the situations in which information will be shared. I also think it will need to provide at the very least that the FCA's advice to the FOS will be made available to the firm that's the subject of the complaint, and really I think there's a strong case for publishing that advice generally so that other firms facing similar complaints can see what advice the FCA has previously given to the FOS on that matter. That's obviously particularly important in the context of cohorts of complaints, as Ruth mentioned. All of that, however, is predicated on the basis that information is going to be continued to be shared during the FOS's decision-making process, and as I think Ruth has discussed, that there are real questions over whether that should be happening at all. Right, well, with that whistle-stop overview of the dispute and what's happened, I think we've probably just about come in under time, so we have just a few minutes to answer any questions that have come in. It seems we've only had one in so far, and it's for you, Ruth. It is, if there is a cohort of cases with implications for the sector, should FOS hold an oral hearing and invite public representations from the FCA?
No, I don't think that would be appropriate, because the FCA is not supposed to be a parallel judicial system. The courts and the FCA operate quite distinct processes. For the FOS to hold an oral hearing would be tantamount to establishing itself as a court. It's not equipped to test evidence, and it's not equipped to hear adversarial argument. So if these battles are to be done, I would say they should be done in the court system, where there's all the rules on procedure which must be adhered to, not in the much looser and supposedly much more informal system that FOS operates.
Right, well, thank you. As I say, I think that's the only question we've had in live, and with that I'm afraid to say that we've now run out of time. Thank you very much for watching and for the question that we did have. As ever, if we haven't had the time to consider your question live, or if you are watching this later and you think of a question that you'd like to ask, then by all means, please do feel free to email either Ruth or myself, and we're always happy to take a stab at answering it. That's all from us. Thanks again for tuning in, and we'll look forward to seeing you again next time on Gough Square Live.
Thank you.